Welcome to the Pretty Good Policy for Crypto podcast, where we have in-depth discussions on cryptocurrency policy and regulation. My name is Paul Brigner, and I'm head of U.S. policy and strategic advocacy for the Electric Coin Company. Through these thought-provoking and at times challenging conversations, we aim to deepen our understanding of complex policy and regulatory issues and work towards the development of pretty good policy for the cryptocurrency world. This podcast is for educational purposes only and is not legal or financial advice. My remarks and those of our guests may not reflect the views of our organizations. We hope you enjoy the podcast. Thanks for tuning in. We are very fortunate today to have one of our favorite guests back on the show again for the second time. Welcome, Miller. We are so happy to have you here. Miller Whitehouse Levine, CEO of the DeFi Education Fund. Welcome back.
Thank you very much. It's my pleasure.
A lot has happened since we last talked. It wasn't actually that long ago, but this is crypto, right?
Yeah.
So we've had a lifetime since we last met, and your team has expanded. You've got a lot more firepower.
Oh, yeah.
And this is a very special episode for us because we're adding a remote guest for the very first time. Would you like to introduce your new general counsel, Amanda Tuminelli?
Yes, I would love to. Our new Chief Legal Officer.
Chief Legal
is
Officer.
Amanda Tuminelli, who joined us from Cobra Kim. I will let her introduce herself, but to your point, adds an enormous amount of firepower at a time that it is desperately needed. So we are very thankful to have her, and I think that long-term the DeFi ecosystem will be as well.
Amanda, how about giving us just an overview of your experience and background, and then take a minute to tell us about your first few weeks at the DeFi Education Fund?
Sure, happy to. And Paul, thank you for having me on, and Miller, thank you for the kind words. So I am really excited to be joining DEF as its Chief Legal Officer. We, and Miller can speak to this too, I think one of the most important forward-looking goals we have is to take a more proactive approach when it comes to impact litigation and policy work. And my background has hopefully set me up to do that really well for DEF. So I started my career at Deckert, which is a big law firm, and then I clerked for a federal district judge in the Eastern District of New York. And then most recently, I was at Cobra Kim, which is a global law firm that focuses on disputes and resolutions. So it's litigation only. And there, especially towards the end of my tenure there, I represented mostly blockchain companies and individuals who were accused of various white-collar crimes related to digital assets. So it really gave me insight into what it looks like to be at the recipient of a subpoena or the recipient of an SEC complaint, and gave me a good perspective of what those concerns are and what it looks like to actually be speaking to regulators or the DOJ or lawmakers from that end of the world. But now, or at least in my first few weeks at DEF, it has been a huge change, but in a good way. Going from private practice to industry, your view both constricts and expands in different ways. So instead of representing 10 different clients who have different interests, now you have the interests of the industry to keep in mind. And I would say that it constricts your view because you get to focus on the issues that are related to the industry, but it's also expansive because it is an entire industry of people with opinions. And you get to work with people who are also passionate about the same subject matter as you, which is really nice. So working with Miller and others at DEF has been really, really wonderful for me.
You've joined an amazing team. You've made it even better, which is hard to believe. I was watching something else recently, another maybe podcast, or it was a call that I was on, and Jake Chervinsky of the Blockchain Association made a comment, say that you're the best litigator he knows. So I thought that was a pretty big deal. That's pretty big statement. And from Jake, I definitely believe it. So we are very fortunate to have you in the industry working with us at the DeFi Education Fund.
Thank you. And Jake is very kind. We actually go way back. We competed against each other in mock trial in college. So Jake is a little biased, but I will take the compliment anyway.
A little biased, or maybe he has firsthand experience. So. Well, great. So one of the reasons why you're here with me today is because you guys have been very active since you've just started not long ago. You've already helped put together a very important filing, and this is with the SEC, and I'm not going to try to describe it. I'd rather have you do that. But this is something that Miller and I discussed when he was with me on the last episode. And I remember very distinctly, Miller said, you need to watch this because this could hit any time, and it's, super important proceeding, talking about the definition of exchange. It could change the whole nature of the industry. And then sure enough, like the next week it hits. And I actually have taken that snippet where Miller was talking about that in the podcast, and I made a little snippet on our YouTube channel. So for anyone who wants to go back and look at that, you can, and see what was said then and now, the update. It was very prescient. It was right on, and let's go from there, basically. There is a little history here, so maybe just a brief review of what you did in the first time that this proceeding initially opened. It's been reopened. You filed again. So you want to just give us an overview of all that's happened up to now?
Sure. Yeah. And I will say, what happened in April of this year was not worst case scenario. There is a silver lining there. But let's start at the beginning, which is January 2022. It actually goes back further because the rulemaking was initially proposed several years earlier, but was revivified in January of 2022. And the rulemaking makes changes to the SEC's interpretation of what a exchange is. How it does that is by saying persons who make available communication protocol systems that allow individuals to express non-firm interest in trading a security will be captured as national securities exchanges. That is word salad that I will let Amanda unscramble after we get through the procedural history. So that was January. A lot of folks commented. There was nothing on digital assets or DeFi in that initial release, which is one of the things we, among others, commented on. There's a 650-page rulemaking here. We think that based on a smoke signal from Commissioner Peirce, it could be relevant in the context of digital assets and DeFi. And if it is, SEC, you need to tell us that explicitly, or we don't have notice of this rule's potential applicability to the DeFi ecosystem. I mean, the original intent was around the treasury markets, so very, from like the most traditional plain Jane asset markets, although the most important to DeFi in the last 18 months. So what the rulemaking originally was trying to do is capture what the SEC believes to be entities acting as exchanges in the treasuries markets. The January 2022 release expanded that to all securities, not just treasuries, which was where, given the SEC's unsupportive view, everything in crypto is a security, it became relevant to us, unfortunately. And then when that comment period closed, we didn't know what was going to happen next, as is the case today too. And during our last recording, I said the same thing. It was again reopened in May 2022 for additional comment. Not for any substantive reason, but because the SEC's website had broken during the initial comment period and some comments were potentially missed, so they reopened it in case anyone's comments were missed. Didn't hear anything after we submitted those first two comment letters, and again, a lot of folks in industry did as well, which is very much appreciated. That brings us to the podcast and then what happened the next week. So I think that my fear during our last recording was that what we were going to see next was a finalization of the rulemaking without any DeFi discussion, without any clarity as to its potential applicability to the space. Obviously, finalization is much worse than a reopening, which is, in my opinion, the silver lining here. I think that what happened is that the SEC read all of these comments about the rule's potential impact on digital assets and DeFi, and either said, excellent point. There's debate around this. They either said, excellent point, let's go get them, or they felt as though finalizing the rulemaking without discussing DeFi would make it deficient from a Administrative Procedure Act perspective. The Administrative Procedure Act is this statute that essentially governs how federal agencies are allowed to issue rules, which has the force of law. And in order for there to be public input, they have to go through notice and comment and all sorts of requirements, including giving people fair notice that the rule is going to apply to them. If they don't discuss digital assets and DeFi, how do we have fair notice? April 14th, we got notice. Big time. The SEC didn't re-release the proposal. It's essentially just an addendum, a commentary on the underlying rulemaking. But they released 168 pages that directly addressed questions around digital assets and DeFi. So that the most recent comment period ran through June 13th. And that is where things stand today procedurally. It is back in the SEC's court. We could never see the rulemaking again, God willing, or they could finalize it in a couple of weeks. It's a bandwidth issue and whether they can get through all of the new comment letters. So that is the procedural history here, and the substance is Amanda's bailiwick.
Amanda, it sounds like we're going to you. Do you want to talk about what was in your comments and then where we go from here? What's next?
And what they're proposing to do.
Yes, all that too. Within
the proposal, and I think I will try my best to not completely editorialize as I describe what's in the proposal, but what they're seeking to do is amend the definition of an exchange, right? So they're trying to change what would qualify as an exchange and who needs to register as an exchange. That's super high level. What they're doing more specifically is expanding that definition to capture, as Miller said, communication protocol systems, though I would say that they don't define that anywhere. So it's just, the term is, they're expanding it to include communication protocol systems that make available place. So this definition, the makes available language, the communication protocol systems language, vastly increases the scope of who is captured as an exchange. There's also additional language where the SEC is intending to capture anyone who performs functions that are adjacent to those you would typically think of in running an exchange. So there's this question, and we make this point in our comment letter, of where the limits are of this definition. And I'll transition into just talking about what we say in our letter now. So we make the argument, as did many others in the industry, that this definition is so broad that it captures all of DeFi, and it would serve as a de facto ban on DeFi in the United States. And I think the reason behind that is the way this definition works is any group of persons who perform functions that are similar to what one would think of as running an exchange are captured in the definition of an exchange. So like, who isn't captured in an exchange? We have this great analogy in our letter, which I love, and you've probably seen it already everywhere, but I'm going to say it again. It's taking the definition of a baseball team, which you would think would include the players and the coach, to include the people selling candy and popcorn in the stadium, the people who are supplying electricity to the lights in the stadium, and people selling tickets to the baseball games. And those are not people you would normally think of as the team, but now that the expanded definition, this is the analogy, the expanded definition would include those people within the baseball team. The way that this definition of exchange includes people adjacent to who you would think of as running an exchange. And it's particularly problematic for DeFi because there is no one group of persons running a decentralized protocol, right? There's no, the whole point is there's not an identifiable group of control persons that you could say, okay, you need to go register, or you haven't, you're the exchange, you're the heart of it. So I think that it's really problematic for DeFi in particular.
The implication is that if you are an exchange, that the SEC says as a communication protocol, this DAO or something like that is an exchange. They make that pronouncement. You have to register. What else do they have to do? What are the other implications of being an exchange if the SEC makes this decision?
Well, they get to regulate you, right? So I think it expands and this is another argument we make, is that the SEC this is a jurisdictional grab, right? They're saying by expanding the definition of an exchange in this way, one, they have jurisdiction over anything that constitutes an exchange. And two, they're making the assumption that what's within that exchange is a security, right? So there's like kind of two levels of problems here. And one thing we argue in our letter is that there are major questions for Congress to decide within this that the SEC kind of blows past and just assumes that the answers are resolved in their favor. But I think the SEC is assuming that digital assets are securities. So therefore, they're being bought and sold in this framework of an exchange. And then they get to regulate all of the digital asset industry that meets the definition of an exchange. And I think those are major questions for Congress to answer.
A couple of anecdotes from the original rulemaking and the re-release that I think underscores just how insanely broad the definition is and who they intend to capture. In the original release, they specifically exclude cell phone providers and online messaging platforms from the new definition of a national securities exchange. A communication protocol system, this infinitely ambiguous term, could presumably capture cell phones. If I can, text Paul saying I'd like to maybe buy Apple stock, that would be enough to check all the boxes of the reinterpreted definition. If you need to exclude, cell phones and chat platforms, then why have a rule anyway? It should just be an ad hoc declaration of someone's an exchange because Chair Gensler woke up on the wrong side of the bed that morning. In the more recent release, the SEC discusses what happens if you have an immutable smart contract. If there is no way to change the smart contract via some governance function, the SEC says, no, there is a governance function. The miners and validators on which the protocol is running or the smart contract is running are the group of persons that are now constituting a national securities exchange as envisioned in the Securities Exchange Act of 1934. So way beyond any rational perimeter here. And I think that's intentional because if you have an infinitely broad definition, you have complete discretion over who to go after. Unfortunately, I think for the judicial tolerance of that kind of rulemaking is low, unfortunately for the SEC, and I think rightly so, because if it completely undermines the idea of the rule of law in general. If the rule is so ambiguous that it's meaningless, then it's just ad hoc discretionary action by a federal agency, which is completely contrary to our system of governance.
It's not actually going to stop any of these things from existing, right? They're going to be there. They're going to be running, and people are going to be using them. It's just that people can't use them legally in the United States. And this would make that happen much more broadly, right? Because everything would be an exchange, essentially, and none of it could be used here in the U.S. legally, right?
Well, so that's a couple of points there. I think number one is that a core key difference here, which many folks in the crypto bar have pointed out over the years, between the derivatives regulation in this country and the securities regulatory framework is that exchange trading is not mandated in the Securities Acts. So what that means is that if you are a U.S. person, you are individually not allowed to trade a derivative unless you are trading a derivative on a registered centralized intermediary with the CFTC. The Exchange Act in the securities context does not mandate exchange trading. think to the like 60s or something, when grandma would give you a stock certificate for Christmas. That was a securities transaction that's completely legal because the Exchange Act, unlike the Commodity Exchange Act, does not mandate exchange trading. So what you would have is a de facto SEC-imposed ban on the development of communication protocol systems that potentially allow people to express interest in trading securities. So, if the SEC's position is taken to its extreme, that means miners and validators can't operate in this country if there's an immutable smart contract that allows for the exchange of assets the SEC thinks are securities. The development, making it available, would also not be allowed. I do question the constitutionality of that, as Coin Center commented on quite convincingly during this most recent re-release. But that says nothing about U.S. persons' ability to legally operate in DeFi in the under the assumption that you're touching a security, which is a underlying assumption of this entire conversation, as Amanda pointed out.
You brought up Coin Center's comments. Maybe this is a good time to talk about just other comments that you saw and thought were interesting that have been filed in the proceeding. Any other things that have jumped out to you that we should at least mention here?
Yeah, I think that, this is on the radar of members of Congress, big time. A group of 29 members of the House Financial Services Committee, including the chair, sent a letter on this rulemaking, arguing that it needs to be re-evaluated from the ground up, and that Congress is actively working on markets regulation in the digital asset space, and to stay in your lane, SEC, so to speak. So that one I definitely thought was interesting and was very much appreciated. Obviously, members of Congress saying that this is a issue for Congress to deal with, as evidenced by the fact that they're trying to deal with it, is important. And another letter that I thought is definitely worth reading is Polygon Labs letter. They discuss at length the miner validator issue, more in depth than any other comment letter I've seen. And, the SEC trying to get into the regulation of miners and validators as national securities exchanges, is so out there that I really appreciated their in-depth rebuttal of that concept. Amanda, any letters that you liked?
Well, you took my two.
Oh, sorry.
I was going to also mention the House Financial Services Committee letter and also Polygon's letter. I mean, I think it makes sense that we're thinking about both of those. I think, like you said, it's really important that members of Congress be engaged on this and discussing it and putting out their thoughts. And I think even Congress noted in that letter, or members of Congress noted, that the SEC has a certain hostility, their word, toward crypto. So I think that letter is a really good read. I would also recommend it. And I was also going to talk about the Polygon letter because I didn't see the argument Polygon made in any other letters. There were a lot of great letters. I think Miller could tell you about Uniswap's letter. I think that there are even just individual people who wrote in, individual developers, individual users of DeFi protocols, of other centralized exchange protocols who have feel personally affected by the rulemaking if it were to be finalized. But on the Polygon letter, which I thought was really interesting, they talk about how validators run in a network that cannot constitute a group of persons, but one might imagine how the SEC would interpret a group of validators as a group of persons, and that is what is so dangerous about this, right? Validators either cannot or most often cannot operate in conjunction with each other, or decide to operate in conjunction with each other, so they can't coordinate in a way that the SEC clearly contemplates when they are talking about the group of persons that they mention in this proposed rulemaking. So it it's just like it's like an impossibility when applied to validators in a network. And I think the Polygon letter does a really good job of making that point and also just explaining the technology. I think for most people who don't have a great background, as I didn't, not that long ago, on how validators work, I think it does a great job of giving you that background and explaining why this rule would be really, really problematic for any network that operates on validators.
Another interesting letter that is noteworthy is Bloomberg LPs. They have commented on this repeatedly and have probably submitted more information on it than any other commenter. They, I think, are under the impression that their business and services are not securities exchanges, and they would be captured as communication protocol systems that allow people to express non-firm interest. So I think that one's certainly notable, and they do, I think, or at least as in the letters I read, the most comprehensive job of pointing out how much guesswork the SEC has thrown into this rulemaking and the most recent release. The phrasing, the commission preliminarily believes XYZ, is seen throughout the rulemaking, or we don't have enough information to analyze this, is everywhere throughout the rulemaking. Which, in my mind, is compelling reason, are compelling reasons for the SEC not to be doing this rulemaking. But, I think seemingly the commission's position here is that they thought it, and therefore it must be true.
So you're pointing out some things that are clearly major issues with the rulemaking, where they just don't have the evidence, they don't have the analysis there to support it. Makes me think there's probably ample opportunity to attack it from a litigation perspective, or maybe other ways. So what are the other ways that we might be able to address this if it does happen to go forward?
So assuming that it gets finalized, the next steps would be to challenge it in court, right? So it would be an APA, Administrative Procedure Act challenge. And it would be a little bit specific based on who the named plaintiff is, right? Because depending, like Miller's example of the Bloomberg letter, like Bloomberg would be affected by this rule in a specific way that might be different from how a DeFi protocol would be affected by this rule. But the legal challenge would likely be under the same framework, which is that this rule violates the Administrative Procedures Act and maybe a constitutional right or another constitutional doctrine would be, you would also tack that on and bring that in the same case. So I think it will depend on who the plaintiff is, but I think it will be a rush to the courthouse if this rule gets finalized.
Yeah, in both crypto and TradFi, for sure.
I'm just kind of adding to the list of litigation out there that we're seeing grow, seems like every week, right? We have a few major cases outstanding.
This one would have SEC as a defendant. It would be a different procedural posture for the SEC to be responding to a complaint as opposed to bringing a complaint. So this was an allusion to just like the regulation by enforcement atmosphere where the SEC is suing industry participants. And I think that this would be bringing the fight to them instead of waiting for them to draft a complaint and bring the fight to the industry.
Yeah, and credit where credit is due. They are doing rulemaking. They've come around to doing rulemaking. Unfortunately, it's not based on rationality or facts, and is a ban, which is a policy-making decision that we don't believe they have. But yes, touche SEC. They published a rule.
I'm sure glad they did, because I think any rational person who looks at this and hears what you're talking about is like definitions around communication protocols generally being securities exchanges just doesn't make any sense. I wonder if some of those cellular providers or other companies are now taking another look at this, because they were carved out initially, now they're not potentially. Makes me wonder, if you look at the overall filings, did you see any other unexpected players jump in? Do we see it like a Google or an Amazon, or you'd think that they might want to pay attention to this?
See any ISPs or anything like that? I think it might be evidence of a problem more than evidence of it not being a problem, because I think that the infinitely ambiguous definitions certainly capture those entities, but their position is, well, they don't mean us. Again, that whole concept is a complete refutation of the idea that we live under the rule of law.
Right. Yeah, that's not the way we should be making policy, and very concerning, very concerning. Well, we talked a little bit about a potential legislative fix, right? You said that we had a nice letter from some other people in the House Financial Services come into this proceeding. We do have market structure, draft legislation, other things that are coming soon, I've heard. Do you guys want to talk a little bit about that and say how that is looking as a potential fix for this problem?
I will let Miller get into the specifics of the market structure bill, but what I would say is I think the industry, the digital asset industry, has been asking for a rule, asking for clarity and clear law for a really long time. And I think it reflects a good effort by Congress to do that. And I think anytime we can increase our audience among both parties, that is an opportunity for us to educate people, and that's a good opportunity. So I think at a super high level, it's a good thing. Whether it actually, passes anytime soon is a different question. But in the meantime, I think we can have this discussion, and we at DEF can use it to talk about DeFi with members of Congress.
Yeah, and I'll add that just to give context here, the market structure bill that we're referring to here is the bill that the House Agriculture Committee and House Financial Services Committee's majority staffs put together and released a discussion draft of a few weeks ago. Very notable that these two committees put a bill together because chairs of committees generally don't work together. When they do, it's a big deal, especially House Agriculture Committee and House Financial Services Committee. Why is ag involved at all is a logical question here. The agriculture committees are involved in crypto policy debates because they have jurisdiction over the CFTC and derivatives trading, which is a consequence of historic use of derivatives to hedge commodity price fluctuations like wheat, corn, etc. So we have this, I think groundbreaking, historic, probably most comprehensive market bill that Congress has ever put together come out. And I think that, one thing that as an organization we're constantly have on repeat is the necessity from a policymaking perspective to differentiate between CeFi and DeFi. They're completely separate systems. They function in different ways. It's like Western Union versus a cryptocurrency network. One operates in a traditional intermediated way, and one operates using software. And trying to apply the same regulations to both is completely illogical, as evidenced by the SEC's proposal to do just that in the context of centralized national securities exchanges like the New York Stock Exchange and DeFi protocols. The market structure bill takes the opposite approach, which is the logical approach also adopted, for example, by Bank of France in a recent consultation paper. The market structure bill attempts to solely focus on the CeFi portions of the market, similar to how Europe approached the CeFi issues first in MiCA, marketing crypto assets regulation, and are now getting after the more the Gordian knot of DeFi in the context of regulatory questions. So I think that the market structure bill attempts to do that, and I think does it pretty well. It's trying to solely focus on the centralized portions of the digital asset markets, and in order to do so, limits the applicability of the bill's regulatory provisions to what it defines as ancillary activities, many of which we think are relevant in the context of DeFi. If this bill became law, probably not terribly likely, those ancillary activities would apply to not just the provisions in the bill, but the acts, the total acts that they edit. And one of those is the Exchange Act, which is the statute under which the SEC's proposal has been promulgated. So I think if anyone had any shot of following that, the net is that it would be somewhat helpful in ameliorating concerns around the exchange rulemaking.
It would put these things in this ancillary bucket, and then it would at least open up new rulemakings and new things like that.
My
right?
general read of the market bill, obviously it's fresh off the press and
right.
is subject to active
and it's pretty
debate.
big.
Yeah. Oh, it's big. It's big.
Yeah, so I really think that's a wise approach, though, to say let's just focus on the CeFi things, because to be candid, over the past year or so, not all, but many of the major issues that crypto has experienced and that regulators look at and don't really appreciate are CeFi activities.
Yeah, setting aside bridge hacks, that is completely accurate. Not only that, where the problems have been primarily, but also that is where 95% of retail consumers touch digital assets, which are the folks that policymakers are most keen about protecting. So, when you have 5+ million wallets on Ethereum that have interacted with the DeFi protocol, probably relatively sophisticated actors compared to Coinbase's 100 million retail customers, I think from a consumer protection, market integrity perspective, the priority should be and is CeFi.
Good. Well, some things seem logical. Not everything, obviously, but this is a good thing. So you mentioned the Markets in Crypto Act, MiCA. So it seems like EU is moving forward a lot faster. So they've got MiCA now. You've said they're going to be focusing on DeFi next, potentially.
Yep.
How is that going to affect your advocacy? Is that going to be something that you're going to try to focus on as well? I know it's hard to cover the whole world, but that's going to be a pretty important thing.
Yes, 100% it's going to be important. And we've been light touch engaged out there for the last 2 years. But primarily, I would say the DeFi banner is being the vanguard of DeFi policy advocates out there is an organization called EUCI. A lady named Marina runs it. They are an excellent organization and have been doing a great job engaging not just on the implementation of MiCA and its touching of DeFi potential, the Data Act, which was a bill that potentially touched smart contracts, among others. So they are certainly the group to follow for EU DeFi policy developments. But I think, in general, I completely agree with you. Europe is far ahead of the US, not just from a process perspective, but from an intellectual perspective. An excellent example from this year being the Bank of France proposal. While there are many, many problematic things proposed in it, it begins with the CeFi versus DeFi discussion and says it is illogical to think about trying to accomplish policy objectives in these two worlds in the same way. That doesn't mean it's impossible to do so in DeFi, and saying so is stupid, but it is just as stupid to say we could apply CeFi world, old world regs to software protocols. So let's abandon that idea and go from there. And again, that is antithetical to the SEC's approach to date.
Wish that they would have the same forward thinking when it comes to privacy, because privacy is not always something that I believe is handled the right way in the EU, and especially in what's happening in their anti-money laundering statutes that have been proposed recently.
Yeah, I mean, MiCA is not perfect. Don't get me wrong, and I'm sure whatever comes down on DeFi will also not be perfect, probably euphemistically, but anything looks rosy compared to the US at the moment.
To build on what Miller was saying earlier, another thing that DEF is focused on is this week we will be putting in a response to the HMRC's consultation, which is a call for comment in the UK on their new tax regime as it relates to DeFi. And I just think it's worth mentioning why this is such a positive effort, and not to be too negative about the US, but I think a better effort at rulemaking, because what HMRC did is originally they put out like 3 separate options, where option 1 was apply the existing tax framework to DeFi protocols and returns. 2 was consider this amendment to the existing framework. And 3 was create a new framework. And they called for comments on that, and they decided to go forward with a new framework. Like they're actually writing new law in order to capture or to make rules about how to tax DeFi returns, how they would define DeFi returns, and through lending protocols, through liquidity pools, that type of thing. And this, what we will be saying in our letter, is, this is a smarter way to go about rulemaking in this area. Like, let's start from the ground up. Let's do things that make sense for DeFi, instead of just trying to jam it into an existing framework. So I think that's worth mentioning as a positive example and a way that, the UK is out in front of the US.
I'm really glad you mentioned that. Of course, we talked about the EU, but for the UK, they're really making a push for Web3, right? Just in the past few weeks, we've seen some organizations make announcements that they're moving to the UK, are opening offices in the UK. A16Z did that, for example. So that's interesting, right? Is UK going to be the Web3 and DeFi home for the future?
I don't know, but I do think they are, winning the race right now, to a certain extent. The funny thing about what winning the race means in this context is not some regulatory framework that's super permissive or allows, a bunch of nonsense to go on unchecked. It's just anyone with some sort of logical approach is immediately winning the race, because we have, policies like those proposed by the SEC here in the US to compare them to.
Yeah, that's amazing. It's such a low bar. All you have to do is propose legislation and regulations that actually make sense, that are logical.
It's so easy. Yeah.
One thing I wanted to mention today is that, as is usually the case, we have this podcast. We record the podcast just after we do the PGP for Crypto breakfast here in DC. And we had some great speakers this morning. We always do. We had Paul Brody from EY talking about Nightfall and privacy in the enterprise space and how important privacy was. And of course, I think you all know how important privacy is to me and to the Electric Coin Company and to the Zcash ecosystem generally. But we also had Kristen Smith, the CEO of the Blockchain Association, talk, and she was reflecting on how amazing it is that this draft legislation we already talked about is moving forward so rapidly. In fact, there is a markup scheduled, I believe, for July 19th. And I think that's happening not only on House Financial Services, but it's happening on the ag side too. It is amazing that we have a markup scheduled. I think it's actually historic. And you alluded to that we have these committees coming together. I've been in crypto for a few years now, and Blockchain Association has been around for 5 or so years now. I've seen that happen over the course of the time I've been working in this space. This is amazing progress.
Yeah,
right?
It's insane. Yeah, I think we first met in 2019, Paul, and I was about to say, if you'd told me that this bill would be out there in 2023, I would have certainly called you a liar. So it really is, it's crazy.
Yeah. I remember when it would be very rare to see anything crypto related on any financial news service. And now it's constantly on CNBC.
If they even mentioned the word crypto, we would all text each other. And now I feel like half of congressional hearings are on our issues.
Especially this year. It's been amazing. So I think we should just take a moment to pat you on the back and you, Amanda. It's we are making progress. And the fact that we see so much of this pushback, frankly, and these hurdles that we're having to address, that's a good thing. So we all should keep that perspective, right?
100%. Yeah, I think, I always tell people one has to be an irrational optimist to work in DeFi policy. But I think that people need to remember, DeFi is a technology and crypto is a technology that's really trying to upend a lot of how the most fundamental systems of our society operate. And that is going to be a 50-plus year journey. There's going to be ups and downs, but I think it's impossible not to see, the world fundamentally reshaped by all of this technology over a 50-year time horizon, for the better.
Yeah, I think that's right. It's not easy to make these kind of changes, and the systems we have in place weren't put there overnight. It took many, many years to get them there, so we shouldn't expect it to be easy. But the fact that we're on this track is just really encouraging to me.
If it were easy, it probably wouldn't be terribly revolutionary.
You all, thank you so much.
Thank you.
You've shared so much information with us. I know everyone's going to appreciate that. I appreciate your work. You are leading the industry, and we will certainly have you back. Because no matter what happens here, something will happen, right? We are going to have some resolution.
I don't know, maybe in 10 years.
10 years. No.
Yeah, we don't. We actually do not know. We could literally never hear about it again.
So this rulemaking could just fade away.
Yeah.
Okay.
Well,
Or not. Well, I suppose I hope it fades away, at least until we get that legislative fix or something else to fill that void. But if it doesn't, you will be back, right? We're going to talk about what's next, likely litigation. So, Amanda, we're really going to need to hear from you at that point. And we're going to hear all your brilliant strategies for pushing back on this if it does move.
Thank you for having us on. And yes, you will be the first to hear if this rule gets finalized, what the next steps are.
Keep up the good work, and thanks for being on the PGP for Crypto podcast.